Correct.
This is a well-recognized principle of renunciation. If a person does not claim inheritance within a reasonable period, then he or she is deemed to have renounced that claim and therefore not entitled. Now, this is a all-important question of Muslim law, which needs to be considered by this.
Yes. Yes.
Please, my lord. Now, my lord, the Learned Senior Council has pointed drawn your lordship's attention to a judgment. I'll just take your lordship to that first.
Of the Privy Council.
Please, my lord.
Yes.
It's 1871 judgment.
1871.
Yes.
Yes.
That's the para that he read out.
Yes.
Now, the same para, my lord, that last para on internal page 10.
Yes.
It says, my lord, they may further remark that according to the Mohammedan law, there may be a renunciation of the right to inherit, and that such a renunciation need not be expressed, but may be implied. From ceasing or desisting from prosecuting a claim maintainable against another. So the word clearly used, my lord, is maybe. Now, taking one step further, my lord, when an application under Order 7 Rule 11 is considered, it is a plaint above must be looked into, my lord.
Yes.
Now, that being said, my lord, my plaint discloses the cause of action. I have stated very clearly.
Come to para 22.
Para 22.
Yes.
That is page 31.
Yes.
That the cause of action for the above suit arose on 24/1/1999 when Al-Haj CJ Abdul Qadir expired and his mother Hajia So-and-so inherited share in Schedule B properties owned by him on 10/2/2008 when Hajia Ami Abi expired and the plaintiff and defendants inherited undivided shares, right, title, interest, and claim of the scheduled properties, and defendants 5, 6, 7, and 8 being beneficiaries therein. 2, in view of the demise of the spouse and father of them, respectively, on 29/1/1999 and subsequently on 2/8/2016, when the plaintiff and the 9th defendant, by a notice issued to their counsel so-and-so, demanded a partition of the scheduled properties of meets and bounds and delivery to them of their respective shares therein. And when the defendants 1 to 8 failed to comply with the said demand to effect a division by meets and bounds of the aforesaid scheduled properties, and defendants
was
failed.
it an intestate death?
Yes, my lord. It was interstate, my lord. Now, my lord, my case, my lord, is that I have been approaching them subsequent several occasions to seek a partition. That's also called out in para 21. They have kept. If your lordship will also see the written statement, this very same plaintiff, the defendant number 4, who has filed this application, she files 2 written statements, my lord. First, I'll point out the first written statement, which is at page...
Order 7 Rule 11 only plaint tower.
No, my lord. No, in the written statement, she says we are ready to partition the property.
Where is that?
That is at page 42 is the written statement. Your lordship will see page 48. Page 48, para 7, the last 4 lines, my lord. This is what they say. Now, this is the written statement filed by defendants 1 to 8 jointly. These defendants have always been ready and willing to give the legitimate share, right, and entitlement of the plaintiff and defendant. Number 9, subject, however, resolution of the issues pertaining to the properties as referred to herein above. So this is what she says in this written statement. Then, my lord, para 11, page 50, para 11. Though the notice was received by these defendants did not choose to reply as they were intending to resolve the matter amicably without the recourse to litigation. So this suggests, my lord, that I have been approaching them several times. They have kept me hanging, my lord, and then I have no other option. I have come to the honorable court and filed the suit. Now, my lord, she comes up with an additional WS, which is at page 55, where she takes other contentions with regard to certain properties that she seeks to incorporate and make some. That's at page 55, my lord. Now, D4 only files this additional written statement. And if your lordship would,
what is this?
She says that there are some additional properties that are also concerned, my lord. This was filed much later, my lord, in 2023, and was allowed on cost of 25,000. Now, in both these written statements, my lord, there is absolutely no plea of limitation that is urged. Both the written statements are silent. Now, what happens, my lord? After this application for rejection of claims is dismissed, she comes up with another application before the trial court seeking to file a third written statement where she wants to take these contentions of limitation, my lord. So, lordship might see that as on date, this is nothing but an afterthought. This is nothing but an attempt to protract the proceedings. There is no pleading whatsoever in both the written statements filed by her with regard to the concept of limitation. That being said, my lord, it is the point of limitation is a mixed question of fact and law. It will be decided by a trial, my lord. And even the judgment they relied upon clearly says it may be a renunciation. So that will also have to be examined by evidence. So on these submissions, my lord, and this honorable court is also in another judgment, my lord, which is not on Mohammedan law but on a case of partition, a coordinate bench. I'll just take a lordship to para 15, my lord. In view of the matter, this court is of the agreement that with the trial court agreement with the trial court in coming to a conclusion that the issue of limitation raised at the hands of the defendants is a mixed question of law and fact, and therefore the same is required to be considered after looking into the evidence that could be adduced by the parties in a full dress trial. At any rate, suit for primary relief of partition and separate possession cannot be rejected at the threshold on the ground that law of limitation would apply insofar as the deed of relinquishment is concerned. Now, my lord, in this particular case, there was an express document, which is the deed of relinquishment, and they took the contention that that would be a ground for limitation. But notwithstanding, my lord, at the threshold without evidence, the proposition of law is that it cannot be rejected without evidence. So on these submissions, my lord, my whole submission is that there is no merit in the application. The trial court has rightly dismissed the
No
application.
other judgment you
No,
have.
one more judgment is that the Supreme Court on the point of limitation.
Where is the latest?
It is.
2025 SEC online SC 1208.
I'm not aware of the judgment. But I will look into it. So this judgment, my lord, head note D.
Yeah, all old ones.
Yeah, I know. This concept, my lord, is about what is the period of limitation. They are urging it as 3 years. But here it says, my lord, Article 144 would apply, which takes it to 12 years, my lord. So notwithstanding that, even on the argument that I've kept out for 7.5 years or 7 years, 9 months, it was within the period of 12 years, my lord. So that being said, my suit is within time. And on that point, the writ petition has the CRP has no merit.
Consider. Yes. Heard the learned senior counsel.
I may reply, may I?
Anything in rejoinder, sir?
Yeah.
Any submission in rejoinder, please?
Yes. My learned friend read out the pleadings. My written statement at page 48. Kindly come back to page 43 in the same written statement. What I have said.
43.
Yeah.
Yes, sir.
Para 5. The plaintiff has provided details of 24 items of properties described as plain C schedule properties. The following properties are not available for partition is the specific case. All the properties, practically all the properties in schedule C up to item number 24, that is KL